Do you ever ask the attorneys if you can meet with the clients privately without the attorneys?
I try to avoid that. I will do it if an attorney suggests it, and if we set some parameters on what it is we're going to do. But to me, that feels a little intrusive into the attorney-client relationship, and the last thing I want to do is kind of insert myself in the middle of that. So I typically do not do that. And I recognize there are some cases where the dynamic I get from meeting with the attorney and the client is that there would be a real benefit to talking to one or the other one out of the presence of the other one. But I really try very hard not to do that unless somebody requests it.
So do you have some sort of an estimate as to what % of cases never go to mediation or any kind of alternative dispute resolution?
Wow. We're talking about cases that would ordinarily, because they're not Social Security cases or prisoner cases or stuff that doesn't go. That's got to be well under 10%. As a court, we really are committed to making sure that people go through a mediation process. Again, we are trying not to suggest to people that they shouldn't want a trial, because if anybody wants a trial, I mean, that's what we're there for. And that's dispute resolution too. It's just a different kind of dispute resolution. But we don't want anybody to walk into a trial not having fully explored the possibility of reaching a settlement through mediation. So we're pretty adamant about forcing people through the process at some point. Judge Smith, for example, I know I just did a mediation for him, won't set a trial date in a case until people have participated in the mediation. He just won't do it. And I think all of our other district judges, to a greater or lesser extent, have a similar philosophy. So it's going to happen in a case that otherwise is going to go to trial. I think that's a pretty safe bet.
I think another, at least from my experience down there, in federal court, you have an order. You have an order from a judge or a magistrate judge that says you'll attend, the parties will attend, the trial counsel will attend, you'll exchange statements, reasoned demand and a reasoned response before the mediation. We got to a point in common pleas where you would show up and an insurance company would send an adjuster who had no knowledge of the case, just so they had someone there. Or even worse, you would have law firms, nobody particularly in mind. You'd have law firms who, instead of sending the trial counsel who knew the case, they'd just send an associate down who knew nothing about the case. And at least among a lot of the attorneys participating in it, there was a lot of frustration that it's just a waste of time. The way you do it, my memory might be wrong, but my recollection is you put on an order once sanctioning an attorney for failing to show up at a mediation.
Yeah, I have done that.
I have used that when I get parties who aren't, complying with the order. And I just reference your order. It says, this is a court order, guys. You need to obey it.
And as far as exchanging demands and offers as well, we try to stay on top of that. And when we do ask our mediators, if you don't have those materials by the time required in the order, again, call the court, and we will actually call attorneys and say, you're late with your mediation statement, and when are you going to get that in? So we do try to provide some administrative support to make sure that the process actually goes the way it's supposed to go.
I think the atmosphere of the common pleas courts has completely changed. I remember when every judge involved himself or herself in the settlement process, and it was like a priority. And today, I don't get any pressure in the common pleas court to either mediate, talk, or resolve a case. They just set it for a hearing, and off you go. I mean, the judges all seem to be indifferent to the process, not just formal mediation, but I remember Shoemaker. I mean, he was very much involved in getting cases settled, as was George Smith on your court.
Mm-hmm. Yeah, courts do have different cultures, and it changes over time as well. I feel very fortunate that we've had the continuity that we've had in our culture and our program. And even though we do get judges from common pleas background, most recently Judge Frost and Judge Watson, both common pleas judges, they seem very willing to adapt to the existing culture of the federal court and kind of internalize that and make that their own culture too. So I think that continuity is...
Well, Judge Watson had great training and mentored him in our law firm. That was years ago.
Yeah. Any other questions before I move on to another subject? I wanted to just highlight for a couple of minutes a slightly different menu that you get if you're in a different district court. And has anybody here litigated or mediated a case in the Western District of Pennsylvania? Okay. If you go to their website, and I got onto this because at the Magistrate Judges Workshop in April, and one of the sessions was on mediation, and we had people from other courts come and talk about how they did it. And I was surprised to find out that there are quite a number of courts around the country that require people to participate in mediation where they compensate the mediators. I've always felt a little bit uneasy about forcing parties to pay a private individual as part of the judicial process. And I asked that question, kind of a threshold question, well, how do you kind of get away with that, I guess was the way, I didn't exactly phrase it that way. And the response was, well, nobody ever objects. And I'm still not sure how I feel about that. But if you look at the Western District of Pennsylvania, they maintain a list of mediators who have filed a fee schedule with the court for mediation. And when they send a case off for attorney mediation, they basically tell the parties, here's this list. And I looked at the list this morning, and it's a long, long list. It's several hundred people. And the parties are supposed to pick a mediator. And if they can't agree within 10 days, then the court will pick one for them. They assign the case to that mediator. And then the cost of the mediation is borne equally by the parties. And they have some language about if it's a two-party case, you split it 2 ways. If it's a 3-party case, you split it 3 ways. They have a fee waiver provision for parties who are indigent who can't afford the mediator's fee. It's actually not a fee waiver provision. If you prove to them that you can't afford to pay for it, they have some mediators who've said, well, we'll do pro bono cases for just in those situations where one of the parties can't afford to pay the fee. And you go off and you do your mediation, and we're required to compensate the mediator at whatever rate it is that the mediator has listed on the fee schedule. I looked at the fee schedule. There are some bargains on there. There are some folks who say that they will mediate, and I guess you have to put in a range from dollar figures. So the lowest range I saw was $100 to $199 an hour. And there are quite a number of people on that list in that range. And maybe for some of them that is basically pro bono practice. And then there are people who do half-day rates and full-day rates and case rates. Case rates were like $900. Full-day rates, I think I saw one for $1,500. But it's kind of all over the map. And I guess one of the benefits is that if you do want a particular mediator for subject matter expertise reasons or mediator expertise reasons or whatever, if that person is on the court list, then you can actually get that person for your case, but you do it as part of the court process. And my sense is that the reason people would do that rather than just go out and hire that person is that maybe people have listed lower rates on the court schedule than they would otherwise charge. So that may be the bargain part of it. But that is very clearly a pay-for-play system. And it's not unique to the Western District of Pennsylvania. There are quite a number of district courts around the country who have a similar process. So that's a slightly different model. And I have had questions from time to time about, well, why don't we do something like that here? And I guess to me, there are at least 2 reasons. One is we haven't needed to. We've had such a great response from the bar for volunteers that we've never really needed to try to figure out a way to attract mediators by offering them compensation. And the second is, as I said, I've got this personal uneasiness about the court forcing people into a process like that where they have to pay a private person. I can understand having to pay court fees. You got to pay a filing fee to come to the court. That's fine. That money goes to the government. The money we're talking about does not go to the government. It goes in somebody's pocket. And I'm just worried about that relationship there.
Just by way of information, in West Virginia family courts, they have an approved list of mediators, and the West Virginia Supreme Court sets the fee schedule based upon gross household income.
Interesting. Okay. And I can actually kind of see that too. If you set the fee schedule, you have people say, we'll mediate for the court for a fee, and then the court pays them directly, which I assume is what happens.
No. These are private pays, but the fee is set by the court's approved fee schedule.
Interesting. Okay. Leon.
I'm familiar, Judge Kemp, a little bit with Florida, which also has a statewide mediation, actually in practice. And you have to have, I think it's 40 hours of training or something really extreme. You have to be certified, and it's mandatory, and they get paid. But they also, I think, sort of earn their stripes in a sense, because the facilitative notion, well, very little is normal in Florida, but I think the facilitative notion is probably not a strong one, because these folks, I think, are competing for jobs. And so, for example, I'm aware of a situation where, again, no one particularly in mind, but insurance lawyers had been instructed that certain mediators, and this is statewide, certain mediators will not be employed by that client's case protocols because they're viewed as plaintiff's lawyers. Once you get past a certain line with mediation, it becomes a business. You have exactly the same pressures that you have in everything else. And so it's a big business there, and there's a lot of advertising. I get the Florida Bar newspaper and so on, and there are pages of certified arbitrator, and they're seeking business in that same sense. And I think they get jobs done, but I think there's a certain amount of bragging there that, well, I settled this case not because I facilitated it, but because I browbeat, I'm capable of accomplishing that. And so there is another side to the story that's not as glowing and sunny as we have it here in Ohio.
Yeah, that's a good point. Yes.
And I mean, the point I was going to bring up is because I practice in a court that actually orders parties into not only mediation, but if they can't do mediation, then it goes to evaluation like an E&E, and then it goes to a court investigation. So they have you pay for all of that. So if you're putting the price on the actual litigants, you could compare mediation to the court costs that it would go through for a trial, and then give them the option of, look, you can pay this little amount for a mediator, or you can pay this much bigger amount. So, I mean, would that be possible as a way to at least keep, I mean, it does affect the whole mediation community if mediation is just, offered for, for free. So would it be possible to consider that way that the litigants would then, take mediation as